So, we're looking at a family provision case, and, well, it's about the effect of estrangement between a deceased person and their adult child. The case is Keaton versus Gumilak, decided in 2020 by the New South Wales Supreme Court, matter number 943, and the judge was Hallen J. This case concerned a claim for provision by the deceased's adult daughter. The deceased passed away on May 31, 2018. She left a will dated May 27, 2018. The plaintiff was the first child of the deceased, having been born to the deceased and her first partner. Shortly after the plaintiff's birth, the deceased and the plaintiff's father separated, and the deceased met John Joseph Gumilak, who is the defendant. The deceased and John went on to have 2 children together, being the defendant and another daughter. It was not in dispute between the parties that John would at times physically discipline the children. The plaintiff left the family home when she was 16. She continued to receive some financial assistance from the deceased. However, the precise amounts and regularity of this assistance was not disclosed. The plaintiff had 3 children, 2 from her first relationship and 1 from her second. In 2014, the plaintiff was diagnosed with PTSD and borderline personality disorder. She believed that the PTSD was caused by the discipline and harsh treatment imposed upon her by her stepfather, although there was little medical evidence to support this belief. By the deceased's will, she appointed the defendant as executor of her estate and bequeathed all of her jewellery to be shared between her youngest daughter and 2 of her granddaughters. She also gifted 7 legacies of $10,000 each. One of these legacies went to the plaintiff. This was the only provision made for the plaintiff in the deceased's will. The rest and residue of the estate was divided between the defendant and the deceased's youngest daughter. At the date of hearing, the agreed estimated value of the estate out of which provision could be made was $892,901. The nature of the relationship between the deceased and the plaintiff was described by the plaintiff as very close. However, there was some evidence which did not support this conclusion at times. The plaintiff focused on her relationship with her stepfather during her childhood, which she described as abusive. The plaintiff claimed that the deceased was aware of the abuse suffered by the plaintiff. However, she did not do anything to intervene or prevent it. Between 1986 to 2018, the relationship between the plaintiff and the deceased varied from close and supportive to distant at times. There was evidence of arguments that had taken place between the plaintiff and the deceased that resulted in periods of little to no contact, as well as evidence of a supportive relationship between the parties. In 2014, the plaintiff was diagnosed with PTSD and borderline personality disorder. The plaintiff contended that the deceased did not provide an appropriate level of support at this time. The plaintiff gave evidence that the deceased consistently denied the existence of her condition and the cause of it. When the deceased was diagnosed with cancer in 2016, the plaintiff was instructed not to visit her. Ultimately, the defendant contended that the deterioration of the relationship between the plaintiff and the deceased was the responsibility of the plaintiff due to the choices she made. At the time of the trial, the plaintiff was living in rented accommodation with her 2 sons and her father. She had a small amount of cash in the bank and 2 super accounts totaling approximately $50,000. She was on Centrelink benefits and, received a small amount monthly in child support payments. Decision. His Honour considered the principles relevant to claims by adult children, particularly that the community does not expect a parent to look after his or her children for the rest of the child's life, that there is no need for an applicant adult child to show some special need or some special claim, and that the adult child's lack of reserves to meet demands is, well, a relevant consideration. Hal and Jay considered the estrangement between the plaintiff and the deceased, noting that, while it was for a significant period, it did not actually destroy the ties between the deceased and the plaintiff. He held that the nature of the relationship at the time of the deceased's death did not preclude an order for provision being made in favor of the plaintiff. His Honor considered that the plaintiff was not in a strong financial position, and that, in light of all of the circumstances, a lump sum of $10,000 made in the will of the deceased constituted inadequate provision for the plaintiff. So the next question for His Honor to consider was the provision that would be adequate for the plaintiff. In deciding this point, His Honor considered that the plaintiff and the deceased had, well, virtually no contact from late 2015 until the date of the deceased's death. His Honor noted that, while estrangement does not preclude an order for provision, in this instance it actually restrained the amplitude of the provision to be made for her. In the circumstances, His Honor considered that in lieu of the provision made for her in the will, the plaintiff should receive a lump sum of $95,000 to allow her to pay off all her debts and leave a fund for the exigencies of life. His Honor ordered that the defendant's costs be paid on the indemnity basis out of the estate of the deceased, and that the plaintiff receive a specified gross lump sum instead of assessed costs, being $66,800, for her costs of the proceedings, to be paid out of the estate of the deceased. For any assistance, please contact MJM Lawyers, your trusted New South Wales wills and estate lawyers, led by our founder Michaela Money, who became a solicitor in 1998 and has been an accredited specialist in wills and estates since 2009. Visit www.mjmlawyers.com.au to book an appointment or call +61 028089 3139. With a wealth of experience, Michaela Money and the team are here to guide you with confidence. Liability limited by a scheme approved under professional standards legislation. Disclaimer. This post contains information of a general nature only and is not intended to be used as advice in relation to a specific matter. Although every care has been taken in preparing the document, it may not be accurate or complete, particularly in the context of specific circumstances. MJM Lawyers disclaims responsibility for any errors or omissions.